Hello everyone, myself Deepak Gupta, and in this session we will take up the contract of agency. So, as we all understand that in a business you need someone to enter into various kind of activities on your behalf. So, when someone commonly known as a principal appoints another person, and that person should act as a representative of himself. So, what I'm saying that when we take up various business activities, then you appoint people who can act on your behalf and whatever they commit to the third party, and you are ready to oblige to them. So, such people who act on your behalf will be known as the agents. So, the person who authorizes another person to act on his behalf is known as a principal, and such person who is acting is known as agent, and this relationship of principal and agent accrues with the contract of agency. So this contract of agency is subject to the following rules, where the acts of the agent are deemed to be the acts of the principal. So the basic purpose for which the agency has been created is to assure that whatever kind of activities will be entered by the principal, then the same should have been, or then the same could have been entered into on behalf of such principal by the agent, and the principal authorizes all such acts of the agents within the authority limits. So, whatever the principal may do by himself, he may get the same done through such agents. So, this is just a relationship where instead of doing all the work by himself, the principal appoints someone else to perform all such personal nature relationships. And the important thing about this contract of agency is that whenever we talk of any contract and we say that contract is a two-party contract between A and B, where one person makes the offer and the another one accepts it, but this contract will always be a valid contract if there is a consideration. The Contract Act and the definition of the consideration under Section 2, subsection D of the Contract Act 1872 has not quantified the consideration. That is, the quantity is not important, but the presence of the consideration is a must. And this contract of agency is an exception where there can be a valid contract between one party known as the principal, the another party known as the agent, and they can enter into such kind of contract even without consideration. So we are not saying that there should not be or there cannot be any consideration, but it's a choice that whether you want to make such contracts with consideration or without such consideration. And that is what the basic requirement is all about. So, keeping in mind this thing, we can always underline that this contract of agency of appointing one person to act on your behalf. That is, the contract of agency can be created either expressly or by implied actions. So basically, there are different ways of creating an agency. An obvious one, like the types of the contract, can be that there can be an express contract between a person and they spell out either in an oral format or in a written format the terms and conditions of their such association. So whether the expression is oral or whether the expression is written will not make an effect, and such either oral or written expression of the contract terms is known as creation of agency by express terms. But sometimes the behavior of the two parties is such that it is presumed that they are in a relationship of contract of agency, that is, one is principal and the other person is acting on his behalf as the agent, and their actions justify the existence of this implied agency between the two. So we can say that implied agency is to be something which is understood from the conduct and the behavior of the parties, and in spite of there is no express agreement between the two. So obviously the creation of express agency is valid and justified and should not have any confusions, but such creation of agency on implied terms will have implications, and therefore it has been clearly defined in various three parts, that agency by the estoppel, agency by holding out, or agency by necessity. So this word agency by holding out implies that or before we enter into this holding out, we should first understand the agency by estoppel, because they more or less are similar, as we have written here, that the agency by holding out is almost similar to the agency by estoppel. So before I move on to the holding out, we should understand the meaning of this word estoppel. So when we write this word estoppel, so it basically denotes that something you cannot deny. So we can say that what you have said you cannot deny. It is not like that you say something now and then you back out from your words. So if you have said something, if you have uh, acted as some in some way, that is, a person has made certain representation, then he cannot subsequently retrieve from that. And this representation can be oral, that is what you have expressed by your words or by your actions. So whether it's a visual representation or whether it's an oral representation, they both will justify that in no way a person can or once make a representation and regressively back out from that. So therefore, once you accept the agency by estoppel, that is another person is relying on your such representation, then the person who is acted in such a stupid way cannot deny the fact, and therefore he will always be deemed to be the agent and in a relationship of contract of agency, and will be bound by all the liabilities and the rights of being an agent. So therefore, this preclusion to deny the truth is what you call a stupid. On the similar terms, if I express the word holding out, then we obviously by the word holding out means you are showing that you are agent, and that looks similar to the estoppel, and therefore we say that the agency by holding out is almost similar to the word estoppel, because in addition to such estoppel, there is also an affirmative action. So not just your presentation. So if I say that your representation, that your representation will make you an agent by estoppel, but your representation along with your supportive actions, if they both are together or your actions are supporting your representation, then we can say that it's an agency by holding out. So effectively, holding out can be defined as an upper version of estoppel, as you have justified your estoppel by your uh, positive conducive actions. But sometimes a person may not be wanting to enter into any kind of contract of agency, but the situation is such that he has no other way out and has to act on somebody's behalf. For example, अगर आपको रोड पे कोई आदमी किसी का एक्सीडेंट हुआ और वो किसी नॉन कॉन्शियस वे में अनकॉन्शियस वे में पड़ा हुआ है, देन एज ए गुड सिटीजन यू विल ऑलवेज वांट दैट इसकी डेथ ना हो जाए, तो आप इसको या इसको एक सीरियस इंजरी ना हो जाए, और उससे बचाने के लिए मे बी यू टेक हिम टू द हॉस्पिटल एंड एडमिट इट. बट नाउ सम लॉज हैव बीन amended, but ideally when you take him to the hospital for admission, then you will have to fill certain forms, and then you will have to sign such form. So you are not actually authorized on that unknown person's behalf to sign because you're not his agent. But you are forced by the circumstances that if you don't sign and if they don't admit, and you will be feeling that that person will suffer for the causes. So in spite of the authority of agency not being hounded on you by such principle, you act as a agent and sign on his behalf. So the circumstances are so much compulsive that you have to act by the concept of agency by necessity. So when there is a concept or there is an agency by necessity caused by compulsory situations, then it is also a kind of implied agency. And therefore, there are the three conditions which justify that it must not have been possible to communicate with the principal and obtain the instructions. Like in this case, the principal was not conscious, so you cannot take his command to act as the agent. And secondly, you have done it in the best interest of the principal. So you are not doing it for your personal gain. You're doing it for certain good of the person whom you want to save or the person who will be deemed as your principal. And this has been justified in various cases such as cement company versus Midland Railway Company. Their English laws, colonial laws, which justify the facts that these must be justified to be covered by the contract of agency by necessity. So therefore, the word existence of emergency is always must because that will only create the compulsory situation which justifies your action to act as agent. And in this three concept of implied agency. This agency by ratification is a special case because in the earlier cases, the action of agent were initiated by the agent himself. That is, the two parties, principal and agent, and of the two, the actions of agency were initiated by the agent person himself. And in this case, agency by ratification, the principal has undertaken a purposive action and which justifies and ratifies your position as the agent, even though there was no express agreement between the two. So we can say that, or I could increase the scope of the example that what is happening that whenever there is any contract of agency, the principal will always delegate certain powers to such agent. And this agent has to work within those powers. And therefore, if there is any breach of such clause, then the agent shall be liable for such actions. But sometimes you take certain actions even though they are not within the powers of yours as provided by the principal, but the good faith of having or to save the principal for certain bad effects, you take certain actions which are outside your content of agency, and the principal underlies them, and then he ratifies those actions which, though were not within your powers, but he has ratified your these actions. So, this ratification of we could say uncovered actions, and this uncovered actions denotes the actions which were outside your power, and once they have been done, तो we can ऐसे बोलूं अगर मैं कि जब वो एक्शंस करे गए थे तब आपकी पावर में नहीं थे, बट आपके प्रिंसिपल ने उन एक्शंस होने के बाद उन्हें रेटिफाई कर दिया या उनको पावर के अंदर कवर कर लिया या उनकी रेमिफिकेशंस को एक्सेप्ट कर लिया, देन इट विल बी द एजेंसी बाय द रेटिफिकेशन एंड इट हैज टू फॉलो वेरियस रूल्स एंड द प्रिंसिपल रूल हैज टू बी that the ramification has to be whole. Either whole actions to all actions are to be covered, or I can say if a particular action is there, then you can't ratify the part and leave the part. So there has to be the whole ratification of the act. So as they say, the whole of the act must be ratified and no partial ratification is justified. So you cannot ratify partly, either you don't ratify, and if you ratify, this has to be complete. Similarly, this ratification has to be within the reasonable time. So this reasonable time depends upon the nature of the action and circumstances. So until and unless there is a timely and complete ratification of the actions of the agent, this will not be covered by the agency by ratification. Thirdly, when the agent undertook the action on behalf of the principal was in existence. For example, you cannot act as an agent on behalf of a person who has not born yet. Or if a company is in the process of incorporation, So the company will come into existence only if it is incorporated as per the Corporate Act. Therefore, the persons who take the actions on behalf of the proposed company before such company has been incorporated are known as promoters. And their actions cannot be binding on the company because even though they are acting for the good of the company, even though they are acting as an agent of the company, but the company has not come into existence. Therefore, the company, after coming into existence, basically signs and creates new contracts once it has been incorporated. Because the earlier contracts which were taken on behalf of the promoters cannot be ratified because the company was not in that stage in existence. Therefore, once the company is created, there will be directors who will be acting on behalf of the company. And though the promoters and directors can be same, to the similar contract which were entered into before the company's incorporation, can again be created freshly, and then they will be signed by the directors. And therefore, earlier contracts cannot be ratified because they were not in existence when the company came into the being. Now, if we see again that only the legal acts can be ratified, illegal acts obviously cannot be ratified. And before you do any ratification, you must have the clear knowledge and clear understanding of what you are ratifying. So, if you undertake ratification without understanding, then or without some misinformation, then this ratification will not be justified. And both the parties, that is the agent and the principal, must be competent to enter into a contract because contract of agency must justify all the requirements of a valid contract, which involve valid parties who are uh, liable or who are able to enter into any kind of contract. Now, before I move into there, we have to understand the implication of how an agent will be liable in his personal capacity. So, normally, agent undertakes any action only on behalf of the principal. So whatever an agent has done, all its liabilities will fall on the principal if the acts have been covered within the parameters of the authority provided. But in certain cases, not the principal, but the agent will be personally liable. So where the agent will be personally liable are specialized, and that is why they need to be learned. So these are the specific cases where the agent will be personally liable, and they include that if you are an agent and the principal is in a foreign country which is not under the jurisdiction of that country, then all the legal action will be initiated with the agent. So when you become or when you enter into any kind of contract with a foreign principal, then you should understand that the implications of liability will fall personally in your capacity. Similarly, whenever you sign on behalf of a principal, you have to mark as an agent here on behalf of the principal. So if you sign in your personal capacity, then it is not an action taken as an agent, and that creates your personal liability on the matter. Similarly, like in the case discussed above, the promoters acting on behalf of the company will be personally liable for all such contracts. For example, if they hired a professional to incorporate the company and the company after being incorporated fails to pay their charges fees, then the promoters are personally liable to pay such expenses because the principal was non-existent at that moment. Similarly, if the principal's identity has not been disclosed, that is, principal is undisclosed, then he will not be liable for anything because he is not under any identity issues will justify the liability of the agent in his personal capacity. Fifth point we have already discussed, all the actions will be falling on the principal if they are within the authority. So, if any agent overrides his authority and takes into any action which are against the authority, then he will be personally liable on such matters. So, for example, if principal authorizes an agent to make a purchase of maximum 5 lakhs, and if the purchase amount is more than 5 lakhs and the principal is declining to make the payment, then the extra payment shall be made by the agent in his personal capacity. Then, if he is done by any fraud or mistake, then this mistake or fraud will be his personal, and the agent will be liable in his personal capacity, as the principal will not undertake liabilities for such mistakes or fraud. And lastly, there can be an express clause in the contract of agency between the principal and agent where, on certain matters, it has been agreed that the agent will be personally liable. And that is why we say that this express agreement of personal liability between the principal and the agent also makes the agent personally liable on such matters. Now, once you have entered into such contract, once you have entered into such contract, then it is not that it is a one-way contract. You can always enter from such agency by any of the following ways. For example, if the agent become insolvent, then the contract itself gets stands dissolved and you are absolved of your liability as an agent. Similarly, there is there can be some contingent or uncontingencies or certain unplanned activities which which make the whole purpose of agency irrelevant and it or may term the agency as illegal. For example, the current sanctions on Russia will create you have created various franchises, and this agreement of franchisee between the principal in a American or European country and with that franchisee holder in Russia as contract which is illegal because of declaration of the war, and hence they have been declared unlawful. Similarly, the prime purpose for which the agency was created has been destroyed. So the subject matter of the destruction will always just nullify your agency. Similarly, agency can be for a particular period, and if the time expired, the agency expires. One of the principal or agent, if he dies, then the contract of agency is being a personal contract nature, then it also expires. Similarly, the business is closed, then the agency seems dissolved. And also, it can be a intentional revocation. That is the way you on your own created the contract of agency. Similarly, you can always back out from such contract and revoke such contracts. And therefore, when there is an intentional revocation of agency, then the agency contract stands rejected. So, on these basis, the agency can be terminated. Only in the following cases, an agency can be termed as irrevocable because if the agency is coupled with the interest. For example, the principal and the agent contract creates certain personal ownership patterns with the contract, then it is not possible that the agent backs out of the contract or the principal backs out of the contract. Then such so if there is any expressed interest between the two parties along with the contract of agency, then such agency becomes irrevocable. That is why we have this word substantial interest along with the remuneration. For example, involvement of director in the ownership of the company along with the salary will make the contract irrevocable. So it is only justified if there is a mutual termination of such agency. So there are various factors which justifies that a contract of agency is the need of the hour. But before we close, we should also understand that a principal appoints an agent, and if the agent appoints a sub-agent, then the actions of the sub-agent will bound or can bound the agent only, but they cannot bound the principal. That is, if the person who is termed agent has entered into another subcontract for agency, then such a subcontract of agency and such a sub agent created will not bound the principal, or principal will not undertake the liability of the actions of the sub agency, because contract of agency is a personal contract. So we always say a delegate cannot further delegate, and therefore, ideally, contract of sub-agency is not allowed in a contract of agency, with the exceptions as listed here. Only and until, for example, if there is a custom of trade, only then sub-agency can be allowed. For example, person selling mobile can sell the mobile only through his authorized representative, that is authorized dealers, but that is not possible to sell all mobiles there. So there are various people who are all selling the similar mobiles, and this will in a way is creating sub-agency contracts. And the principal, that is the company whose phones are being sold, cannot deny the warranty on the ground that I am not under any liability for the actions of the sub-agent, because it's a custom of trade to enter into all such kind of contracts. And on this note, we close this session. Thank you.